Custody for high net worth families is not about the money, it's about the complexity. Your children's lives involve international travel, private school, household staff, and routines that a normal parenting plan was never meant to handle. In Illinois, divorce and custody records are public by default. For families with public profile, a visible business, or a place in their community, that is a real concern. The good news is that Illinois law lets the court keep certain records private: interviews, reports, investigations, and testimony. Your attorney asks the court to seal those records and explains why keeping them private matters for your child and your family. Beyond what the court seals, your parenting plan itself can include privacy protections. Rules about what each parent can share publicly, including on social media, would be part of your agreement, and there are consequences if either parent violates these terms of the agreement. Education decisions are one of the most contested issues in custody cases in families with resources. When both parents share decision-making authority and cannot agree on what school their child should attend, the court does not pick the school. Rather, the court decides which parent has the authority to make that decision in choosing the school. That distinction matters. The legal question is not which school is better, it is which parent is in the best position to make educational decisions for the child. Your attorney helps the court understand your involvement in your child's education, how well you know what they need, and how you make decisions for them. Families that rely on childcare and nannies need a parenting plan that can address how that process works through two households. Standard parenting plans do not account for this. The place this tends to create the most conflict is something called right of first refusal. Right of first refusal means that when one parent is unavailable during their parenting time, the other parent gets the first opportunity to care for the child before a nanny or babysitter might step in. In a family with a nanny, the question becomes, does routine nanny care during one parent's time trigger that rule? The answer depends entirely on how the provision is written in the parenting plan. A well-drafted provision sets a clear time threshold, so routine childcare does not turn into a fight every week. Your parenting plan should include those clear thresholds, practical exceptions, and a simple notification process that works for both parents. When Illinois courts look at what is in a child's best interest, they look at the life the child has been living. For your family, most of the time that includes more than the basics. Activities, enrichment programs, sports, summer programs, travel, those are not just financial questions. They are a part of who your child is and how they live. A well-built parenting plan addresses how those activities and experiences continue across both households, so your child's daily life stays as consistent as possible. When travel is part of your family's life, the plan needs to address that too, with enough detail that a trip does not turn into a dispute between the parents. If your family situation requires a parenting plan that addresses these details, talk to a family law attorney who can build a plan that applies to your family.